Ladies and gentlemen, welcome back to the IndieZone. My name is Kathy. On the 12th of December, the clerk of court released a number of documents that the state of Idaho filed in Idaho versus Kohberger on December 6th, 2024. That date, the state filed several items under seal, several items that were not under seal. So the public does not know what is contained in those documents under seal because seal means that they are not being released on the public docket. The other documents that were not sealed were released. I'm going to go over the one that is on the public docket with you in this presentation, and I want to also go over briefly what a Frank's hearing is and what it relates to and what must be shown for Mr. Kohberger to be entitled to it. First, I want to give you just a little bit of a background. On the 14th of November, Mr. Kohberger filed defendant's motion for Frank's hearing. Then 4 days later, he filed a memorandum in support of that motion for a Frank's hearing. The first is on the public docket. The item of November 14th, 2024 is available to you. You can read it. Unfortunately, the November 18th document is under seal, and that's where a multitude of, it sounds like exhibits, 2,000 pages, were submitted by Mr. Kohberger to the court, trying to persuade the court that he must do under Frank's versus Delaware, which is what the case law is that he references and that he is asking for this hearing on. He filed, we know this, we know the number of pages because there is a court order on November 22nd that Judge Hippler entered, finding the filing to be improper, not that he's denying the motion, but the manner in which it was provided to the court. He gave Mr. Kohberger until November 26, 2024 to refile a proper motion following some instructions that the court is submitting here in this November 22nd order. Why did Judge Hippler require a refiling? Well, he says here in the November 22nd order that accompanying the motion for this Frank's hearing are 38 exhibits comprising over 2,000 pages of documents. Unfortunately, defendant's memorandum largely fails to identify with particularity the relevant portions of the exhibits, instead referring simply to the exhibit number without identifying the precise pages at issue. So there's 38 exhibits comprising of over 2,000 pages, and what it sounds like the defense did here is rather than go to page number 1902 of this 2,000 pages, he's referring to exhibit, let's say 38. The court gives an example of what happened here in a footnote. By way of example, defendant cites generally to exhibit D as in David 9, for the proposition that law enforcement's vehicle expert felt more comfortable setting the date range of 2011 to 2013 for the Elantra. And if you look at the Affidavit of Probable Cause, which is document number 1 on the docket, you know that Detective Brett Payne, who swore out that affidavit seeking a warrant to be issued for Mr. Kohberger's arrest, addressed a white Elantra. He referred to it as a sedan, a Hyundai. And so what the court is referencing here, 2011 to 2013 for the Elantra, is the vehicle that Mr. Payne references as suspect vehicle 1 in that Affidavit of Probable Cause. However, what the court goes on to say in this footnote, that exhibit is over 100 pages of duplicative emails. So what he's saying here is that the court found that if there was an email dated December 1st, 2022, for example, that was submitted multiple times instead of just once. defendant does not identify which email supports his proposition, the court will not do the defense counsel's job and scour the exhibit, go through all of these 100 pages for that point, for that fact. Ladies and gentlemen, that the defense is trying to persuade Judge Hippler helps entitle them to this Franks hearing. He's not going to do the defense counsel's job. Go through these exhibits and decide which portions of the defendants must be suggesting supports his assertion relative to suspect vehicle 1. Now we go back to the body, page 1 of this order. The court is left with the unenviable task of sifting through pages and pages of largely irrelevant documents to ascertain what portion defendant may be referring to. The court is not required to search the record looking for evidence. Venable versus Internet Auto Rent and Sales, Inc. This is a 2014 Idaho Supreme Court case that Judge Hippler quotes here. That it's not his job to scour the record and to find what the defense is asking the court to look at. Next paragraph. Consequently, if defendant wants the motion to be considered, he must file a revised memorandum identifying the relevant portions of the record by page number and, in parentheses, line number if referring to testimony, end of parentheses. What does Judge Hippler mean here? Well, if you're going to submit another email regarding suspect vehicle 1, you need to identify with specificity which exhibit attached to your motion you want the court to look to by line. But if you want the court to consider testimony of some witness, for example, the defense put on the stand at various stages in the proceeding while it was in Latah County, various defense witnesses. Cy Ray was one. Dr. Brian Edelman was another. If you want the court to consider one of those witnesses or another witness's entirely testimony, you must point to the transcript that the court reporter took down where you're asking a question of that witness and what the witness is testifying to. If you look at a transcript from a hearing or from perhaps a deposition, it could be, the court reporter will have page number, line number, question, answer, question, answer. That's what Judge Hippler is referring to. Don't just provide the transcript. You got to go to the page number of the point that you want to be considered for this Franks hearing and the line number. And then also explain why this is relevant to your position. I would argue also. Defense, you don't want to, giving my opinion under the U.S. Constitution, dump 2,000 plus pages on the court's lap and ask the court to do the work for you, to find through these pages, many of which are duplicative as he stated here, what point, what fact you feel entitles you to this very important hearing to the defense. The defense also, per this order, must resubmit his supporting exhibits to exclude portions that are not relevant to the motion. So we get an idea that when this is resubmitted, and it was, the defense did meet the deadline that the court gives here of November 26 to do so, it was probably a much slimmer filing, taking out all of the repetitious emails, taking out all of the items that are largely irrelevant, as Judge Hippler states here. Now, finally, the court says, because the state is under a deadline, you do not have, defense, 2 months to get this to me. He tells us here, the deadline to respond must be on or before November 26, 2024, to submit the, and he says again here, relevant filings, signed November 22nd, 2024, by Judge Stephen Hippler, District Judge, if you would like to look at that order with specificity. What is a Franks hearing? We've seen this term thrown about in this case that it's very important to the defense. Franks is a case from the United States Supreme Court, 1978, Franks versus Delaware. Franks is Jerome Franks, who was charged with and convicted of a crime in state court, Delaware. He exhausted all of his remedies in trying to argue that his constitutional rights were violated. He could not get any relief, he felt, in state court. So once he exhausted all of his remedies in state court, he then went to the United States Supreme Court. The ticket to have the Supreme Court consider a petition for a writ of certiorari, which was what was filed here, you have to either cite a federal statute was violated by a state or a portion of the United States Constitution. Mr. Franks is saying in Franks versus Delaware that the latter happened, that his due process privileges as guaranteed by the 14th Amendment to the United States Constitution were violated. What is due process? We have seen this come up in the Kohberger case a few times. Some of the filings will say he has rights that are guaranteed under the 14th Amendment due process clause. That says that when a state is seeking to take away a person's life, liberty, or property, they are entitled to due process of law. Due process of law has been interpreted by the U.S. Supreme Court to mean three things: notice of what's going on to the party impacted, a right for that party to be heard, and an impartial judiciary. If we look at Franks versus Delaware, and I provided a link for you in the description to this episode of the IndieZone on YouTube, where you can read this very long filing for yourself. One of the holdings here is that where the defendant makes a substantial preliminary showing. So here what Mr. Kohberger needed to do in that revised motion for a Franks hearing that he filed, he needed to make a substantial, a very large, you just can't say a couple of things. There needs to be a substantial showing from the record, ladies and gentlemen, that either one, a false statement knowingly and intentionally, or two, with reckless disregard for the truth, was included by the affiant. This would be the law enforcement official. In the warrant affidavit, there's always going to be an affidavit that is submitted to the court where a warrant is sought. So, this is what we're talking about. If such a warrant was made with a knowing false statement, knowing and intentional, or with reckless disregard for the truth, was included by the affiant in the warrant affidavit, and, next prong, if the allegedly false statement is necessary to the finding of probable cause. So it just can't be, just say, an unintentional or a minor statement. It's got to lead directly to that issuance of the order from the court. The 14th Amendment, as incorporated, the Fourth Amendment, as incorporated in the 14th Amendment, requires that a hearing be held at the defendant's request. Fourth Amendment, that prohibits illegal searches and seizures, and it is made applicable to the states via the Due Process Clause of the 14th Amendment. So now, what we can deduce is that Mr. Kohberger, in requesting a Franks hearing, is alleging that a warrant or warrant violated this standard. He's asked for this hearing. The Supreme Court, turning to the Franks decision, found that the trial court in Delaware in the Franks case erred in refusing to examine the adequacy of the petitioner's, that's Mr. Franks, proffer of misrepresentations in the warrant affidavit. So if you would like to review this case, as I've said, go to the description of this podcast episode and you can pull it up and read it with specificity for yourself. So that basically is what a Franks hearing is all about. That is Mr. Kohberger's burden of proof in trying to persuade at this point Judge Hippler I'm entitled to this hearing? Well, the state had a couple of things to say about this. On the 6th of December, they filed two things. One, the meat and potatoes, their response to, I'm sure it is opposing this Frank's hearing, is under seal. All of their counter evidence and their argument and their memorandum and their legal authority is under seal. We can't see that. What we can view is this document, also filed on the 6th, released on the 12th of December. Stipulated motion to seal state's objection and exhibits to defendant's amended motion. That's the motion that they filed the second time that they're responding to now. And memorandum in support for Frank's hearing. It says here, comes now the state of Idaho by and through the Latah County prosecuting attorney, and hereby moves the court pursuant to Idaho Court Administrative Rule 32G1 and Idaho Code statute, this is a statute, 74124, for an order sealing state's objection and exhibits to defendant's amended motion and memorandum in support for Frank's hearing. Herein, and these are the 5 reasons that they have given a few times now in this case that are misnumbered. I went over another filing yesterday in our last episode of the IndieZone, and I've seen this happen time and time again. Either the state is somehow, by coincidence, misnumbering these reasons, or they're cutting and pasting. That is my opinion that I give here under the U.S. Constitution, First Amendment, freedom of speech, and the press. What are these 5 reasons? 1, if they are released to the public, they would, not could or should or might, but would, number 1, interfere with enforcement proceedings. I think what they're saying here is law enforcement proceedings. 2, deprive a person of a right to a fair trial or an impartial adjudication. 2, this is the second number 2, constitute an unwarranted invasion of personal privacy. And if we go on to the second page, you will see misnumbered 3 should be 4, disclose the identity of a confidential source, and or 4 should be 5, disclose investigative techniques and procedures. The undersigned has contacted the defense and they have no objection to this motion. The state respectfully requests that the court seal from public disclosure this document, and they recite the law that they provided on page 1, Idaho Code section 74124, and the rule 32G1. If you would like to review this document, please go to the docket for December 6th, 2024, and you can read it for yourself. I would appreciate your comments, your thoughts on what you feel about this matter. I read every comment. They're very important to me, and I thank you very much for your feedback. And I also thank you for joining us here today at the IndieZone.